The Great Fraud, 1930 to 1933. 1930. Franklin Delano Roosevelt represents the United States of America, Inc. at the Geneva Conventions. G5 nations agreed to declare bankruptcy by treaty in international jurisdiction in May of that year. Plans to remove from the gold standard are made. 1933. 3 years later, FDR is elected President of the United States of America, Inc., and promptly pursues USA, Inc. domestic bankruptcy as well. The banks name their trustee, the Secretary of the Treasury of Puerto Rico. See Federal Title V annotated for details. March 6, 1933. The Conference of Governors is told that the United States of America, Incorporated, is bankrupt. They immediately pledge the good faith and credit of their states and the citizenry thereof in support. This can only refer to the territorial citizenry, as FDR already committed the municipal citizens during his first inauguration speech. March 6, 1933. Nobody mentions that their states are merely franchises of the United States of America, Inc., and that their citizenry amounts to public employees, African Americans, and corporations formed under the auspices of the U.S. Inc. Note: the actual federation has sovereign immunity and can't go bankrupt. Roosevelt issues executive orders announcing and implementing the domestic bankruptcy and moves to confiscate privately held American gold assets. In all, 20,000 tons are admitted to be taken, 6,000 to back the Federal Reserve, the rest to back the World Bank and IBRD and IMF. The Federal Reserve ramps up its drive to sell people on its Federal Reserve notes, a form of legal tender amounting to an IOU. The process of collecting data on Americans also ramps up. Bureaus of vital statistics spring up, and under the guise of census functions and keeping public records, public registries of property are set up and birth certificates are issued to claim Americans as property, human resources. Birth certificates are used to register vessels in commerce as property belonging to the United States of America, Inc., and pledge to pay the debts of the already bankrupt Governmental Services Corporation. The people who were left uninformed continued to use their trade names as always. The perpetrators claim that this establishes an implied contract and implied consent to be considered citizens of the United States, when in fact there was no disclosure, no apparent offer, and no conscious acceptance of this proposition. United States citizens, territorial persons, and citizens of the United States, municipal persons, serve the federal government, parent corporations. They live either in a territorial democracy or a municipal oligarchy, theocracy, and have no constitutional guarantees. Their labor and their assets are pledged as collateral backing government debt. In return, they receive benefits from the public charitable trust, all of which they pay for themselves. They are subject to every whim of Congress until 1968, and then have only equal civil rights, mere privileges to rely upon. If the birthright Americans lose their claim to their natural unalienable rights, there will be nothing left as a standard for civil rights to be equal to, leaving the door open to total enslavement of the people of this country and the debasement of our society at the hands of Congress acting as plenary oligarchy, Article 1, Section 8, Clause 17. Our private lawful trade names on the land are arbitrarily redefined to be public foreign citizen trusts and operating in admiralty. This is a fraudulent conveyance and a crime known as unlawful conversion, practiced against Americans in gross breach of trust. These newly created foreign citizen trusts are considered to be franchises of the bankrupt United States of America, Inc., and they are subject to the British government under admiralty law. No public notice is given and no effort is made to separate employees from employers. For example, the bankruptcy trustees seize upon the United States of America, Inc., the State of Wisconsin, Inc., and John Joseph Average, an American Foreign Citizen Trust, purportedly operating as a franchise of the USA, Inc., howbeit without his knowledge or consent. The territorial state of state acts as equitable title holder, with the babies left to hold the legal title to their own estates, and presumed to be infant decedents throughout their lives. None of this is ever fully disclosed. 1937. In 1937, the legal title is given to the municipal government, and the baby is merely recognized as an authorized representative, an employee of his own estate. The municipal government doing business as the United States, Inc. creates its own franchise. John Joseph Average, a foreign Puerto Rican CSTQV trust registered in Washington, D.C. by the Department of Commerce to manage the legal title. CUSIP bonds based on the estimated value of our lifetime earnings are issued and traded on stock exchanges. This practice of trading and speculating in the value of human labor is used to fund the government. Federal revenue sharing and block grants are polite euphemisms for racketeering kickbacks and payments from selling tranches of human labor bonds and other public assets. This criminal scam based on non-disclosure, fraudulent conveyance, unlawful conversion of assets, impersonation, and semantic deceit runs from 1933 to 1999, when the bankruptcy of the United States of America, Inc. is finally settled and discharged. But the crime scheme continues. The U.S. trustees, aka the United States Department of Justice, now reverses tactics and fails to reconvey the stolen assets owed back to the American people and the American states. Instead, they place claims of abandonment on our fictional municipal estate trusts and rename the original Foreign Citizen Trust and pretend that now they are public transmitting utilities. John Joseph Average, British-owned and controlled Foreign Citizen Trust, now becomes John J. Average, a public transmitting utility, owned as a franchise of the bankrupt Puerto Rican electrical utility. United States, Inc., State of Wisconsin, John Joseph Average, Foreign Grantor Trust, is in the meantime seized upon by the creditors of the United States, Inc. and USA, Inc. as abandoned public trust property. The banks and others responsible for these deplorable crimes think that they can mount a claim on abandonment and steal everything in sight. All these principals, the Lord Mayor, the Queen, and Pope, owe the American people their assets back free and clear, and so do the courts and banks responsible for this grotesque breach of trust and misadministration of American assets. Two forms of law have been used to promote this fraud scheme, and both are offended on behalf of the American victims of these crimes. Under Admiralty law, the applicable maxim is, possession by pirates does not change ownership. We, the American states and people, are owed back every purloined asset. Under Roman civil law, the law of the municipal United States, the applicable maxim is, fraud vitiates everything it touches. We, the American states and people, have been defrauded by our own employees acting in gross breach of trust and contract. We hereby move the opinion and conscience of the entire world as embodied by the International Court of Justice, the Court of the Lord High Steward, and the Vatican Chancery Court in our favor.